A couple of years ago, a clothing company decided it wanted to trademark its brand named FUCT, which it says stands for Friends You Cannot Trust. The Lanham Act of 1946 created a national system to trademark names. Trademarks are basically brand names that are protected by law, and all the brand names that you know and love, McDonald's, Amazon, Nike, are all trademarked and no one can legally use them except the registered owner. But in a recent decision, the US Supreme Court decided whether you can trademark the word FUCT, pronounced FUCT, legally. No, says the law, because under the Lanham Act, you cannot trademark scandalous or immoral words or phrases, and therefore the past tense of the word is not legally trademarkable. What words are considered scandalous and immoral has been a relatively hot issue in the intellectual property world recently, culminating in a series of cases which led to the FUCT case. The FUCT company tried to trademark its brand name. The USPTO, which is the United States Patent and Trade Office, replied and said, no, you cannot trademark that word because it's scandalous or immoral. So the FUCT company went out and hired the law firm, which stands for Some Help in Trouble, and they filed a lawsuit challenging the rejection of the trademark. The lawsuit challenged the rejection of the trademark based on the First Amendment to the US Constitution, which protects free speech. The US Supreme Court, with the majority opinion being written by Justice Kagan, admitted that the term was vulgar. However, the majority also said that even though it was vulgar, it was protected by the First Amendment because the government had provided no reasonable basis why even a vulgar term should not be allowed trademark protection under the First Amendment. This was a 6-3 opinion, meaning 6 in the majority, 3 dissenting justices, and the dissenting justices pointed out that under this ruling, even a racial slur would allow to be trademarked, and hypothesized from there what might happen if we allowed to have racial slurs on the back of clothing. But at the end of the day, what the Supreme Court did in this case was it allowed it open for Congress to amend the law to provide that reasonable basis for why a racial slur or something like that shouldn't allow to be trademarked. This is something that courts often allow the legislature. They suggest how they can change the law to make it constitutional, and this is a great example of that, the interplay here between the judiciary and the legislative branches of government. The name of the case is Ianco v. Brunetti, if you're interested in looking it up, and that's all for today. Thanks for watching.